Hello, friends, and welcome to another WSIB Truth Matters with Joe Machado. I hope you're doing well today. Today, I'm going to talk about a subject that you've heard me talk about often and how disgusted I am with the WSIB's practice on this. And I get a lot of complaints from members and previous clients about this situation. And that's the issue of having WSIB doctors overrule your own doctors when it comes to pretty much everything to do with medical treatment for your case. The WSIB was never supposed to be in the business of providing medical treatment or let alone medical advice. Generally, medical advice comes from assessing a patient, doing some testing, and then providing an opinion. But these people, they don't get it. And they make life miserable for every single one of you. So friends, we are at war with the WSIB. Injured workers are at war with the WSIB. Some of you are probably still in denial. You may have a current claim going on and nothing's negative has happened. Or maybe you were one of the lucky ones that didn't have any issues. Or you didn't have a claim long enough to deal with these problems. But there's no question that we're at war with WSIB because they are working very, very aggressively to prevent you from getting benefits and treatment that you're entitled to receive under the Workplace Safety and Insurance Act, the Workers' Compensation Act, and every other act before that. But complaint without action leads to nothing. And the WSIB knows that they're winning the war. And here's why they know, because they have the statistics. They know how many injured workers appeal decisions made by them. They know the stats. They know how many go to their appeals branch, their so-called appeals branch, which I think is bullshit. This is all based on my own experiences. If anybody wants to challenge that, believe me, I can talk about this for a very long time. I've seen the stats myself. And they know that a certain percentage give up before they go to the tribunal. So they figure, what the hell? We'll just deny. We'll dictate what they're going to get. Because at the end of the day, nobody does anything anyway. That's their mentality. And until you understand that you are at war with them, they're going to continue to pull this bullshit. And I know people, sometimes they say, well, what can I do? Like, they denied my treatment. They overruled my doctor. What can I do? You can appeal. Now, yes, a lot of people throw their arms up in the air and say, oh, it's not going to go anywhere. They're too big. They deny. I'm going to waste my time and money and blah, 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 blah. But then don't complain about it. Because if you have an issue, you have to appeal. And anytime that they deny something, you must appeal. If it's worth it, appeal it. Because they're counting on the fact that you're not going to appeal. They think you're stupid, me included. Well, no, I've shown them that I know more than they do about their own bullshit policies. But yes, they think that you're stupid or too intimidated or too fragile or too broke to appeal. It doesn't cost anything to appeal. Send in that appeal letter. You're probably familiar with these terms, and I'm sure you've heard them at one point or another. I'm going to put them up on the screen here. Quote, I have reviewed your medical file with the assistance of a medical consultant to determine if deterioration in your work-related condition has occurred. It is my opinion, based on the current medical information received, that your present level of disability, when compared with the previous findings, does not appear to have deteriorated. Really? I have reviewed, I've compared. I don't know of any case manager, director, VP at the WSIB who has a medical degree. They shouldn't be treating a freaking cat, let alone people, or providing advice based on people's injuries and their conditions. Serious matters. Here's another one that you probably heard. I've carefully considered information we have on file. I have carefully considered the information we have on file. And I have confirmed that you have recovered to the point where no further significant improvement in your work-related injury or illness is expected. Do you know how fucking ridiculous that sounds? A 5-year-old could read that or hear it and go, wait a minute. This person must be able to see into the future. They must be an expert. And then this last one, because there's more, but I'll just indulge me a little bit. Based on my review of the medical information, I'm not able to allow the treatment being recommended, grant entitlement for secondary condition, or accept a deterioration of your condition. Holy shit. Wow. That's a mouthful, but they can do it. They can pull that shit out of their hat every fucking day, all day, because they know you're not going to appeal. And they think you're stupid. But here's what the law states. The law states that the Workplace Safety and Insurance Act, actually specifically Section 33 of the Workplace Safety and Insurance Act, this is what it states. The Workplace Safety and Insurance Act provides a worker entitled to benefits under the insurance plan is entitled to such health care as may be necessary, appropriate, and sufficient. I repeat, necessary, appropriate, and sufficient as a result of the injury. Well, who gets to make that determination of whether treatment is being necessary, appropriate, or sufficient? Treatment recommended by your doctors, specialists who have taken the time, the money, and the effort to become specialists in their category. But who has the authority to do that? Because so far, it seems like case managers are doing it. People without a medical degree. And managers are supporting it, and directors are supporting it, and the fat cats upstairs are all supporting it. They even go so far as to say in the policy, pre-approval of healthcare. In some cases, the WSIB must pre-approve the worker's healthcare as well. The WSIB must pre-approve treatment from a healthcare practitioner who's not registered with the WSIB. So they got to pre-approve. Well, why did they got to pre-approve? Because they should consider whether or not it's coming from an accredited doctor. So if they relied on their own internal so-called medical people, why would they need to pre-approve anything? Then it goes on to state, well, here are the doctors that they accept, that they have determined are legit. And this is what they state. A healthcare professional is a member of a college of health profession as defined in the Regulated Health Professions Act 1991. Health professionals included, but are not limited to, physicians and surgeons, chiropractors, dentists and oral surgeons, massage therapists, occupational therapists, optometrists, physiotherapists, psychologists, registered nurses and speech therapy. Well, friends, nowhere on that list does it say WSIB staff. But they seem to use them ever so regularly to turn down the shit that your legitimate doctors are recommending. The policy always states, well, what information do they need in order to make decisions? Okay? Now, decisions about everything, but now I'm talking about medical related issues. Here's what the policy states. Information required to make decisions. Under the Workplace Safety and Insurance Act and the Workers' Compensation Act, workers, employers, and healthcare practitioners must provide the WSIB with information for the purpose of determining entitlement to benefits. Healthcare practitioners. Makes sense. Why aren't they abiding by it? If they're needing this information to make decisions, why are they systemically overruling that information and turning out denial letters at a record rate? In fact, it's about 85% of the decisions are denied based on research that I did recently, and I put in one of my videos looking at workplace safety and insurance appeals tribunal decisions. So here's what they need to do now when they communicate a decision. So whatever denial decision they make relating to healthcare, this and other issues, but I'm talking about healthcare, here's what they're required to provide in that decision letter. So the policy states, a decision letter states the decision, explains the rationale, including any applicable policies, outlines the information used to make the decision, outlines the information used, and advises both parties of their right to object to the decision. And here's where we got them, by the balls. Because I've used this for years. And when they're faced with this, now they have to become accountable. Somebody, their medical, so-called medical professionals, their consultants and whatever, they got to come out from the spotlight or from behind the shadows, and they got to come out to the spotlight. Because it's not just about what you say, but it's how what you say affects other people. And if you're barking orders around and you're providing information for people to use to make decisions that can be very counterproductive to your health, there's a problem. Now, you can go along doing that kind of shit forever and ever and ever, unless you're called on it. When you're called on it, then it's a whole different story. So basically, it's very simple. What they don't expect you to do, you need to start doing it. Every single decision that they make. You need to be able to have them state in that decision. I'm going to put it up here for you to see it. Specify who reviewed the matter. If it was a nurse case manager, put it down. Is that person employed by the WSIB and on the WSIB payroll? Who's paying for that opinion? Is he or she legally qualified in the province of Ontario to provide medical advice pertaining to a patient whom he or she has neither assessed or treated? What is his or her qualifications? What is their medical expertise? Why was their opinion accepted as opposed to that of my own doctor? That is very important. You see, friends, you're now forcing them to say who reviewed the information that was submitted. Why was are they qualified? Why was their opinion preferred as opposed to that of your own doctors? Because I can tell you this, both the Workplace Safety and Insurance Appeals Tribunal and the courts, they will weigh the evidence. They weigh the evidence. They look at what information is provided, and they look at why one medical report is preferred over another. Because they don't play the bullshit nonsense games that the WSIB is used to playing. They will get right down to it. And if you appeal every single decision, whether they deny you Tylenol extra strength or open heart surgery, whatever the case may be, you have a right to know why one opinion was preferred over another, and who paid for the opinion, and is that person qualified or more qualified than your own doctors that are providing you advice for treatment. And the WSIB has to specify, and they have to provide all of these detailed information to these questions. Why? Because it says so in their information when they provide a decision and what is required on that decision letter. But unless you ask for these very specific decisions, they're going to dance around it and go, well, here's another sucker that I denied. And they didn't even think to ask who made this or who provided the opinion for which this decision was made. Because if you don't do this, they are going to continue to rob you of treatment, forcing you back to work without your doctor's advice, against your doctor's advice, not getting the right type of treatment that you deserve, that you need, and some other bullshit type of treatment that was recommended by one of their so-called medical professionals. You know where I'm going with this, right? But in all cases, my friend, you have to have your eyes sight on the tribunal, because they will listen, they will look at it. And so in order to make sure that you are well prepared, every time they deny anything related to medical in your claim, you need to appeal it. With WSIBsettlements.com, my company, on our app, just one click, there are 7 standard letters that you can submit within minutes, objecting to the most often bullshit denials that they engage in. The demand letter, or a letter objecting to the demand to return to work against your doctor's advice. A letter against the denial of medical treatment being recommended by your doctors. The denial of deterioration in your compensable condition. The denial of a pension reassessment for pre-1990 claims. The denial of a non-economic loss redetermination. The denial of a reoccurrence of your compensable condition. The denial of accepting a secondary condition into your claim. And blaming a previous asymptomatic pre-existing condition on the limitations you're experiencing today, which are very real based on your current compensable condition. Not something you didn't know about in the past that you never even suffered from at that time, ever. And every single one of these is one button, a few seconds to enter your information, click submit, you get the letter, and you upload it directly onto their website. It's that fast. And you put it, you stick it to them. You put the ball in their court and see how they deal with it. But each one of those letters provides for the 7 questions that were asked. The details of why a decision was made, who was involved, and all of that kind of stuff. You got to force them to provide that information, because I guarantee you, if you get to the tribunal and you've done your due diligence and you've done what I just explained, tribunal is going to look at it and say, well, nurse case manager denying a treatment prescription from a doctor? Are you kidding me? Friends, once again, thank you for taking the time to watch this video. As you can tell, I am fired up, and yes, because I hate it when they pull this kind of shit. They've been doing it for a long time. Please share my videos with others. I know there's thousands of injured workers out there who need help. We have a very simple system with WSIB, settlements.com. And if you can take a few moments to watch a very short video after this one, I'm introducing a feature to our system that I'm very pleased with, because it's something based on over 30 years of experience dealing with these people, hands-on experience, and having spoken to hundreds of injured workers over the past few months since I started this channel. It's something that every injured worker should have done in their case, because it provides for peace of mind. So anyway, I hope you take a few minutes to watch this. And as always, my friends, Till the next one. Take care. Hello, friends, and welcome to WSIBsettlements.com. My name is Joe Machado. Welcome. You probably came across this video watching one of my many YouTube videos on my YouTube channel at WSIB Truth Matters, or you were referred by a friend or did an internet search. Either way, I'm very happy that you were able to find us. Today, I'm excited to share with you a very significant component of our program with WSIB Settlements that we're introducing to our members and those who need help with their WSIB claims. And that's a case audit, WSIB case audit. I'm excited to share this with you because it's probably one of the most important features and packages that I've ever put together in over 30 years of dealing with injured workers, the WSIB and the Workplace Safety and Insurance Appeals Tribunal. To tell you a little bit about myself, I'm an injured worker like yourself. I had an injury on February 20th, 1986. I'll never forget that date. I had just turned 18, and it literally changed the course of my life. You can learn more about me on one of my videos on my YouTube channel or a little bit in our About page. But I decided early on, many years ago, that I wanted to help injured workers. And that decision came as a result of having to deal with my own challenges, with my own claim, and finding that I wasn't the only one, that there were thousands of injured workers out there who needed help. And the more and more I've learned about this organization, and the more I've dealt with them on a daily basis for over 30 years, the more I'm convinced that they're not there to help the injured worker. And you probably feel that way yourself. This WSIB case audit came about as a result of a number of factors, but primarily injured workers don't trust the system. And in my experience, injured workers have good reason not to trust the WSIB. I have seen over the last 30 years how WSIB has used legislation and policies, their interpretation of policies, to deny injured workers' claims or make it nearly impossible to claim for their benefits. And you've probably asked yourself this question at one point or another, whether your claim is from 40 years ago or last week. What benefits am I entitled to? Did I get everything I was entitled to? What can I expect? A lot of you, probably your cases have already been closed and you think that there's nothing you can do about it. And you probably question whether or not the WSIB provided you with the information that you required so that you can make informed decisions about the benefits that you may or may not be entitled to. It's probably one of the questions that I've had more often over 30 years of dealing with WSIB. You know, I built the largest paralegal firm in Ontario with over 10,000 clients spread out all over the province, from Ottawa to Thunder Bay, Fort Erie, Windsor, and everywhere in between. We've settled over $300 million in settlements for our clients. And I'm not saying this to brag, but it's a fact. And this is one of the reasons why the WSIB hates me so much and fears what I have to say, because they've often tried to shut me down and shut me up, but they can't do it. For those of you who watch my videos on my YouTube channel or who were a client of mine at one point or another, you know that I tell it like it is. I don't mince words. And whether or not it's what you want to hear, it's the truth. And sometimes that means a lot, because if you're being led down a road that's going to lead to nowhere, in other words, your expectations of benefits may not necessarily be aligned with the law. And if somebody doesn't tell you that, you're going to have false hope. And then you're going to be extremely disappointed when you don't get what you want and when all levels of appeal have been exhausted. So sometimes knowing up front what your chances are is important. It's as important as knowing what you may be entitled to or were entitled to at one point and how to go about getting it. And this is where the case audit review is so important. It's not just a regular file review like a lawyer or a paralegal would do, or I did thousands of times and the paralegals working for me did. No. A file review is often a review of the file looking for a particular issue and how to resolve that issue. But a case audit takes a much more in-depth review, looking at every aspect of your case, how it was handled initially, what benefits were paid, were there benefits that should have been paid and weren't? Did the WSIB attempt to limit your entitlement to benefits? And you thought, okay, well, that's what it is. I really can't do any more. Or whether you've exhausted every single level of appeal, and at the end of the road, you didn't get anything. But there may be unresolved issues in your case that were missed. And even if you got to the end of the row, the last level of appeal with the Workplace Safety and Insurance Appeals Tribunal, and this is a worst case scenario, and you didn't get what you expected, it could be that there was a much more important underlying issue in your case that wasn't addressed. And if it had been, the outcome would have been different. I have a member right now who has nearly $200,000 coming to her. She had her case handled by 4 different lawyers and paralegals, and none of them looked at this issue. And the issue was so simple that no appeal is necessary. It was just a matter of knowing what to ask for and how to go about asking for it. So friends, I'm not trying to get you hyped up or all emotional to buy our product. It's not a sales job. Believe me, we have many, many members, and there's many more thousands out there who need our help. But what I'm doing is I'm showing you that not always, or that the word no or deny doesn't necessarily mean that it's the end of the road. And on a better situation, a better case scenario where you don't have to go through these appeals, could be a simple case assessment by looking at and comparing. There's been 3 major legislations over the last 40 years. Each one of them with a different structure to benefits, different laws, how the laws are implemented. And if you don't know how to look at a case, compare the various stages of that case with the laws that were in effect at that point. Every aspect of the law, not just one portion. In other words, not just earnings for the time that you were off work, total temporary disability, Section 37 2B benefits and pre-1990 claims, or a future economic loss award, or a full future economic loss award by applying the presumption clause, or whether your loss of earnings benefits were properly calculated, or whether the WSIB used deeming to calculate your loss of earnings benefits. There are so many different types of benefits that are within these 3 major legislative amendments that if you don't know what to look for, and if you're not focusing on the entire case as opposed to just one issue, you may miss some very important factors. Some of those that can make a huge difference in the outcome of your case and ultimately how you're compensated and how much you receive. So what do you get with our WSIB case audit? The most important thing is you get a detailed audit report. And it provides a description, an itemized description of benefits that you didn't receive, that you may be entitled to receive. It also outlines a plan of action as to how to pursue those benefits, or whether there's still an opportunity within the law to pursue those benefits. And finally, equally as important, an appeal-ready review. You know, I've gone to hundreds, probably thousands of appeals, and there's many times where we were at a hearing before an appeals officer with the Workplace Safety and Insurance Board, or a panel at the Workplace Safety and Insurance Appeals Tribunal. And we discovered at that point that there were some unresolved issues that level of appeal did not have the jurisdiction to deal with at that time, but should be pursued at the WSIB's operating level. Meaning, we'd have to start on one issue from the beginning. Now, we learned quickly, so that didn't happen too many times, but it does happen. The appeal ready review is our way of showing you whether or not you may have launched an appeal. You may have a date coming up, but are you ready? Are you going to be able to put your best foot forward when you get in front of an appeals resolution officer or a tribunal panel? We provide you with a report that tells you whether you're ready or not. And if you're not, we provide recommendations, real recommendations for you to take to make sure that you're ready and you put your best foot forward at that hearing. And there's so many unresolved types of issues that we can address for you as well once we've done our case audit review. And if your case is currently being handled by a representative, whether it's from the Office of the Worker Advisor, or a union representative, or a paralegal, or a lawyer, this is going to give you a fresh perspective, a fresh or a new pair of eyes looking at your case to give you an honest assessment of where you're at and what you can do to move forward, or whether it's time to shut it down. Friends, thank you for taking the time to watch this video and spending a few minutes with me. You can go on WSIBsettlements.com, find out about this case assessment, WSIB case audit, how you can have one done. We've laid out a very simple process, and it doesn't take a long time to do it, but we're thorough, and we want to give you the answers that you deserve. And I also urge you to watch our YouTube channel at WSIB Truth Matters. There's a lot of videos there that provide really good tips on how you can deal with a wide range of issues with the WSIB. All right, friends? Thanks for taking the time to watch this video. Have an amazing day.